Next case is Project Honeypot versus Chernuk et al. And Mr. Prade.
Prade, Your Honor. May it please the Court. My name is John Prade. I represent Project Honeypot, which is an email service provider, and a John Doe consumer in Arlington, Virginia, who tried to buy drugs, fake drugs, online. There are two questions on appeal, Your Honor, but an overarching question I'd like to raise.
Kind of outnumbered today, aren't you?
I am, Your Honor. More lawyers, more spammed websites, more spam, more merchant accounts. We'll get to all of that. The overarching question here, Your Honors, is whether the U.S. Constitution bars U.S. victims from suing offshore banks that systematically turn a blind eye to illegal online pharmacies that are using fake strawman merchant accounts within the Visa and other credit card systems to spam, advertise, and sell harmful, fake drugs without a prescription to American consumers.
Let me ask you a question in response to your announcement. Is turning a blind eye sufficient to create a person, make a person a co-conspirator?
Under the Gucci standard, yes, it is. And I think it comes down to how willfully blind.
So banks say, we'll take anybody's business. We'll take anybody's money. You have mafias depositing tons of money in a bank. You have South American money going into Miami. Everybody knows a lot of that money is probably not good. So the banks become co-conspirators because they could ask questions about where the money comes, but that's not their business.
Well, it is their business, though, Your Honor, and that is a difficult rub, but I think the concept that willful blindness can give rise to personal jurisdiction, even where the entity...
Well, I think you have to get willful blindness as the member of a conspiracy aimed at the United States, right?
Absolutely.
All right.
Absolutely.
And the conspiracy part is the part I think you have to address, because absent that, I don't think there's anything. And that's even a dicey theory.
I understand that, Your Honor.
I'm not even sure it's has the Supreme Court addressed a conspiracy participation, overseas conspirators in a conspiracy that's ongoing in the United States to be in a jurisdiction here, personal jurisdiction?
I don't believe in the internet space that it has, Your Honor, and that's
part on any context. In other words, there could be a very serious constitutional issue. Just because you have liability doesn't mean that the court has power to grab you by the scruff of the neck and bring you before the court. And I don't know if the Supreme Court has ever ruled that that's so, but let's assume just for the moment that a conspiracy theory for jurisdiction would work. I'm not convinced, but would work. Tell me why these banks who are receiving the assets of these businesses in foreign countries part of a conspiracy in the United States.
Certainly, Your Honor. Happy to. In the end, it's because the credit card processing system that's being exploited here is ultimately a very simple game. It's a game an elementary school child could identify. Banks and the merchants and other intermediaries, internet payment service providers, independent sales organizations, and card processors understand that in order to process illegal sales through Visa and MasterCard, you have to do so through straw man merchant accounts. And in order to do that, you have to turn a blind eye as to the identity of the straw man that presents to you on day one. So when that same merchant behind the scenes presents himself to you on day two after you've terminated the first merchant, you can claim ignorance as to the overlapping nature of the identities between those two merchants. That's a simple game. An elementary school child could identify it.
So at the bottom line, have the banks violated some statutory duty? Is this some common law duty, a contract? I mean, how do you get the basis of their duty to perform these functions?
Right. I think there are two bases, really. One is they have violated their contractual obligations to the card associations. Visa has 1,000 pages of operating guidelines that impose tremendous regulations.
Visa's not a party to this case, are they?
No, they're not. But the violation of those regulations, I think, gives rise to an assumption at the pleading stage of willful ignorance.
Let me ask you something. A person in the United States responding to one of these email ads, Canadian Pharmacy or whatever it is, uses their credit card or his or her credit card in the United States. It goes to Chase Manhattan Bank, who issued the card. Chase Manhattan then communicates some kind of transaction to the bank in Lithuania. Lithuania then charges the account or credits the account in Lithuania.
Mm-hmm.
Now, you're saying that you're going to have to come through that American bank, which is doing legitimate business, isn't it?
If it's the issuing bank to the
Yeah, I mean, these
consumer.
American citizens, and I would guess that most of these people have credit cards issued by banks in the United States.
Most of the Americans, yes, making purchase.
Yeah.
On the issuing,
How about John Doe? Where was his credit card?
it was a debit card issued by a state bank in Virginia.
All right.
And
So now Bank in Virginia took his order and charged his account,
mm-hmm.
and then sent that transaction to where?
Well, it actually starts in the opposite direction, Your Honor. John Doe goes to a website. He thinks it's a Canadian pharmacy website, legitimately operating out of a brick-and-mortar
All right, so
space
it goes
in
to the
Canada.
Lithuanian bank. The Lithuanian bank comes back to the Virginia bank and then charges John Doe's account.
Charges his card.
Okay.
Right. He then, part of the complexity of all of
So
it.
now, in coming to the United States, the only transaction that the bank is engaged in is this interbank transaction overseas with the Lithuanian bank and the Virginia bank. Right?
That's the primary purpose of the acquiring bank's involvement, but it's not its only purpose. In the end, banks are involved in the credit card processing system to underwrite the risk of fraud within the system. Acquiring banks, the real purpose of acquiring banks in the system is to guard against the risk that a merchant could fraudulently penetrate the system, generate fake sales using stolen credit cards.
So a Lithuanian bank committing fraud in Lithuania in violation of credit card violations and maybe Lithuanian law should be dragged into the United States because it had a transaction with an American bank?
Where that Lithuanian bank, Your Honor, is systematically authorizing merchants that it knows to a certainty are touching American consumers and are causing...
It's not touching consumers, it's dealing with banks, only with banks.
Not the merchants, Your Honor. The
merchants are dealing with the Lithuanian bank. The Lithuanian bank is dealing with the Virginia bank, and the Virginia bank deals with its customer, John Doe.
But it starts with a spam message transmitted to American consumers who click...
That's by the merchant.
Correct.
You're talking about jurisdiction over the banks.
Correct. But the banks, before they can... The merchants are sending these spam messages for one obvious reason. They're trying to make money. And the reason they can make money is because they know if they can get American consumers to go to these websites, they can conclude a deal. But that requires them to be able to provide the consumer...
Has any American court reached a bank like that and subjected them to jurisdiction? I mean, they have zero contact with the United States. Your argument is that because the internet is global, and it comes to the United States, it comes to Canada, it goes to Latin America, and they sell these drugs, Viagra or whatever they're selling.
My point, Your Honor, is that the internet has, to some degree, forced us to change the way we conceive of what personal jurisdiction means. Because the U.S. Constitution simply requires us...
Yeah, but you're talking about some kind of foreseeability test.
Absolutely.
Well, that's not the test. At least we wrote an opinion that talked about targeting your effort with the intent to avail yourselves of the laws of Virginia.
I think it's important.
And that Lithuanian bank, just because it knew some of the customers down the line were going in Virginia, is not coming to Virginia.
I think, though, it's important to understand what the banks are alleged to have known in this case. Both these banks specifically and banks that play the institutional role that's required of banks that are acquiring banks within the visa system.
Why don't we go after the whole Russian mafia system? I mean, they've affected the United States a lot.
And if a case or controversy involved that, Your Honor, I think that would be an appropriate use of judicial resources, and consumers or American citizens suffering harm, a discernible harm attributable to an identifiable group of defendants, have a legitimate basis for seeking recourse in the courts, and that the U.S. Constitution should not stand in the way to bar them. That's what this case ultimately is about. Before the internet, it was extremely difficult for a Russian thug to reach out and touch American consumers. Today, it's trivial.
Is any of the merchants before the court?
We had named 2 individuals, Your
I
Honor.
understand, but are they before the court?
They're not before the court. And that's
Why not?
Because we don't know who those merchants are. And we don't know who they are because
How do you know they conspired with the banks?
because this conspiracy can't happen without the bank's presence.
So you have John Doe merchants dealing with a bank, and a bank says, I'll do business with the merchants, and you don't know anything more than that.
You have real people communicating with the bank. They aren't ghosts. The problem is, to us, at this point in time, they are ghosts. And that cuts to the essence of what I think Judge Brinkema's decision was based upon. She felt that there was too much of a slippery slope in this case that suggested that if jurisdiction lies in this case, it would lie in any case in which a
She's
consumer...
probably right in that, unless, I mean,
There's an
you
unless.
still haven't, you keep talking about the banks having knowledge or turning a blindfold eye or taking advantage of this business. But that's for their own goods. They don't care about the sale of Viagra, false Viagra, or the sale of this. They're basically a banking institution. And the question is, do they have to filter all the money that comes and goes to their banks? And if they don't filter, are they liable in the whole world for where that money goes?
And there's no doubt, Your Honor, that they are responsible for filtering. They are required by Visa and MasterCard to take applications.
Well, that's a contractual arrangement, right?
But there's a reason why it exists. Again, the banks are in this system to prevent gross fraud, but Visa and MasterCard recognize there's a residual risk of fraud that says...
Is there any evidence on the record that the banks know where a particular email is going or where a particular email went and why a transaction arose?
I think through the chargeback mechanism, Your Honor, they certainly...
All they know is this is a charge. A bank in America sends them a charge.
No, it's a chargeback I'm referring to, Your Honor. When a consumer realizes that they've been duped in some manner within the card processing system...
It could be a defective product, too.
It could be a defective product, but there's...
And in this case, John Doe went to his Virginia bank. Virginia bank credited him. I assume the Virginia bank went to the whatever Lithuanian bank. It credited the account, probably charged the account, and there was nothing more in it. But you're talking about a conspiracy sufficient to bring these entities that have zero contact with the United States except through this banking arrangement into the United States.
And I understand the court's skepticism, and I concede there is a line...
I don't understand what principle we apply.
Well, I think it comes down to an evaluation of how willful and systematic the blindness was. At some point, willful blindness in the Internet space has to be cognizable in the United States, and the Constitution cannot bar it.
Is your claim that whether or not your complaint asserts this, there's willful blindness on the part of the Azerbaijani bank, that bank, do you allege it specifically dealt with the Virginia bank that issued the debit card?
Not that they've dealt directly with the Virginia bank, though they did, but it actually goes through a third-party mechanism within the Visa system. The two banks don't talk. In fact, the banks aren't really...
Well, don't go too far afield.
Okay.
Let me make my question more specific. I'm exploring this not from the question just of sort of some general jurisdiction. Is there like a specific jurisdiction? It seemed to me that's what you were arguing under this arrangement, that you seem to be arguing that since it's a really bad fraud operation, and you may be right, we should sort of look at it slightly different considering the Internet, but that there is, in addition to that, some specific contact with this country in the fraud operation, or either by way of chargeback or initial charge or something that gets somehow that bank involved directly with a Virginia person or bank. Is that true? And is that so alleged in your complaint?
Yes, Your Honor. I see I'm out of time.
You can answer that quickly.
I appreciate that. Yes, there is, I believe, a direct relationship between the acquiring banks and the issuing banks. There may be some intermediary in between, but in essence, that's what happens. There's a handshake between the two of them, whereby the acquiring bank says, we're told your cardholder bought product from one of our merchants. Right. You owe us money.
But so that's sort of like is it a question of, this is a theory that hadn't quite been explored, but the fact those concerns may be assuaged because there is, even though it's indirect, there's a specific contact on such transaction.
Right.
Commercial transaction.
And if I...
That's what you're concerned about, correct?
Correct, with respect to not just the issuing banks being in the United States, but the fact that their cardholders are also in the United States. And
I don't know. No, I'm not asking anything about that. I'm talking about the specific transaction that the communication, the chargeback, and the charge through the bank indirectly goes on this specific charge that goes to the whole fraud operation. It's a specific contact, not a general contact, but a specific contact on this specific fraud operation. That's your argument?
It is part of our argument that the acquiring banks know that these transactions are being consummated.
That has to do with the fraud question. That has to do with the fraud. I'm talking about the contact question. But you claim that the fraud has shown that they should know better. My gosh, the way they conduct business. That establishes, or that goes to the question of whether or not there's fraud.
I understand.
I'm putting that aside for a second. I'm talking about the contact that justifies jurisdiction.
And yes, that's what I'm addressing. They know these transactions, whether they're fraudulent or not. They know that in the end, the issuing banks are domestically based within the United States.
That's not the question I asked.
I'm sorry.
That's not the question. That is sort of a general context issue. I'm talking about, I thought you seemed to be asserting in response to these hypotheticals that there was a specific contact between that bank, although it may be through a third party, back to that Virginia bank on this fraudulent sale. Is that not what you're asserting?
Well, I'm hearing you say the same thing I tried to answer earlier, Your Honor, so I apologize if I don't understand it.
It has nothing to do with the fact that they know generally those cards are going to U.S. citizens. It has nothing to do with that at all. That's what you answered me. I said, are you asserting there's a specific, in other words, there are specific, and you assert in your complaint, there are specific internet transactions back to the Virginia bank from that bank in Azerbaijan.
Indeed, you can tell from the first 6 digit of...
I didn't ask you all that explanation. I said, is that what you've asserted in your complaint?
I believe so, Your Honor.
Okay, all right.
All right, let me ask you one more question. If we assume that you can use this conspiracy theory as a basis for personal jurisdiction, and you further assume that the willful blindness is a sufficient allegation to bring the foreign banks in as part of this conspiracy, they're brought in because they have willfully ignored, as I understand your pleadings, the requirements of their Visa and MasterCard agreements to police, for lack of a better word,
know your customer.
The customer. Wouldn't that also be the grounds that you would bring Visa and MasterCard in as additional conspirators because they aren't policing their own agreement with the banks?
There's not evidence in the record that would establish that level of culpability by the operators of the overall system. Certainly at a policy level, Your Honor, the question you're asking is an important one. Because unlike any of us who are trying to resolve this problem, Visa, the acquiring banks, everyone else in the process that tries to stop fraud, their primary method of doing it is by extracting profits from the ultimate bad guy and saying, I'm taking your money. I'm really angry that you just made premium profit for me. Don't do it again. Out the door with you. Don't come back with that face tomorrow because I'd hate to make premium profit tomorrow as well. It's a very complicated policy argument that asks, at what point do those who have been put in charge of the chicken coop are being allowed to eat some of the chickens, the means of deterring the chickens from staying in the chicken coop? It's a real problem. So
does that mean you would not bring Visa and MasterCard in as co-conspirators?
Certainly not at this point, Your Honor. There's not evidence to suggest.
You've answered my question.
Thank you,
All
Your
right,
Honor.
thank you. You have some rebuttal, Mr. Parade. Mr. Whitney?
May it please the Court. Good morning, Your Honors. Craig Whitney, Morrison & Forrester, on behalf of Defendant Appellee ASD&B Banca. With me today is my colleague, Mr. Huff, also from Morrison & Forrester, Mr. McKeon of Gibbons PC on behalf of ZAO Raiffeisenbank, as well as Mr. Sherrod of Hirschler Fleischer, also on behalf of ZAO Raiffeisenbank, and Mr. Swan of Baker & McKenzie on behalf of Bank Standard Commercial Bank, Closed Joint Stock Company, and Azeragaz Bank.
Where's your bank from?
My bank is from Latvia. That is ASD&B Banca. And I will be speaking on behalf of all appellees here today, Your Honors. If the panel has any specific questions regarding any specific bank, I'm confident that my colleagues would be more than happy to answer those questions. But for the general argument, I'll be speaking on behalf of all appellees.
The facts, for the most part, are generally similar for the banks.
We believe so, Your Honor. We believe so.
Do you think that the other side doesn't make out a, I'm going to ask this, do you think that the other side does not make out a theory that if properly pled would be insufficient? Or do you think they just don't properly plead the theory they're trying to assert? Please don't say both.
I believe, Your Honor, that their theory, even if properly pled, would have been insufficient.
Why, if you could show that a bank overseas was involved in fraud, if you could show that, and you could show that that bank had contacts with a bank on that fraudulent transaction in Virginia, why wouldn't that be jurisdiction over that bank? Because the contact, not general contacts, but the specific contact was aimed at that exact transaction. What would that be?
Well, there's a number of steps there, Your Honor. I mean, first of all, the transaction would have had to have existed with an actual plaintiff that could demonstrate that that bank processed that transaction, which doesn't exist here.
Listen, I'm asking about the theory now. I'm asking about the theory. I didn't ask about the specific facts of this case. I'm saying, why can't you do that? Not is it alleged in this case. Why can't you have a theory like I've outlined that a bank, this is hypothetical, a bank understands and is involved in fraud, and they are, in part of that fraud, the credit card for a person in Virginia is being used, whichever way the line runs, that the money goes from his account issued by the Virginia bank through that account, Virginia bank, back to that fraudulent bank. Why wouldn't that be a theory that would allow jurisdiction over that a foreign bank?
Well, Your Honor, if they
have all that,
if there was sufficient fraud, minimum contacts and purposeful availment with the foreign state.
Wait a second. Don't restate the law to me. I've tried to set that up. Would that be sufficient for personal jurisdiction over that foreign bank?
If there was the sufficient contacts, then, Your Honor, it would be sufficient.
I've already showed you what the contact is. The contact is a Virginia person has a debit card issued by a Virginia bank, and that account allowed the fraud to be facilitated because the person saw the fraudulent scheme, fell for it, and used that card to pay. Would that be sufficient for personal jurisdiction?
Your Honor, I don't believe that would be
why wouldn't it?
Purposeful availment of Virginia in that situation. But I can concede that it could be. It would certainly be a much closer question, Your Honor. I'm not trying to fight your hypothetical. I do believe that it is very far removed from what we have here today.
That being the case, that it could be, then why isn't that established in the pleading in this case?
All right, Your Honor. Well, there's a number of reasons why, and I believe Judge Brinkema very coherently stated it.
You state them. Just state them for me.
Sure. In the first instance, here the plaintiffs have not shown that the bank defendants have any contacts with the foreign state. We'll start with that. So there's no showing of any contacts. I don't believe there's even any dispute on that matter.
They haven't alleged it. They haven't alleged it.
That is correct. They have also not alleged that any of these banks actually have any connection with the alleged merchants in this case. So they don't even have that connection in this case. Furthermore, Your Honors, they don't allege that any of these banks processed any of the transactions at issue in this case, which is a single transaction by one John Doe plaintiff, and there's no allegations that these banks were involved in that transaction. And even further, Your Honor, the only connection, even if you accept all those things, which we submit the plaintiffs have not shown, is that these banks processed a credit card transaction on behalf of a merchant. That merchant allegedly sends spam email. That spam email allegedly reaches Virginia, and on that basis alone, these banks are now hailed all the way from Azerbaijan and Latvia and Russia into court in the United States. And we submit that that is far removed from due process.
I just thought you conceded that at least that last part, if properly alleged, might well be sufficient.
Well, Your Honor, I don't think...
Under the theory, might well be sufficient. At least you wouldn't say that it's completely not sufficient.
What Your Honor had mentioned before, which I think is lacking here, that might have been the connection, was this this idea of fraud and this knowing participation.
No. That has to do with the fraud. That doesn't have to do with jurisdiction. That doesn't have to do with jurisdiction. No. Either my question is not clear, you don't understand me, or I don't understand you. I'm leaving that aside. For purposes of my question. I said, assuming there was fraud, then I was just trying to see what kind of contact would suffice in this kind of arrangement for jurisdiction. That's what I was asking.
I believe I understand, Your Honor. And in this case, I'm not fighting your hypothetical. What I'm saying is lacking in this case with that connection is there is no allegation, there is no proper allegation of that level of fraud.
Let me ask you as a even more general question than Judge Shedd posed. Do the principles, the constitutional principles, and actually sovereign principles when we're talking about country jurisdiction, accommodate a notion that a conspiracy, which is located mostly in foreign countries, but targets American citizens and commits injury, that each of the conspirators is subject to the jurisdiction of an American court?
Well, Your Honor, that's
without other contacts.
An excellent question, Your Honor, and as Your Honor pointed out before, I don't believe that has ever been specifically addressed at the Supreme Court level.
It hasn't in the Supreme Court level, and I guess the argument that lower courts have to make is there's an agency theory, and that an agent can provide a contact on behalf of the principal in the United States. I guess that's got to be the theory.
I completely agree, Your Honor. The Supreme Court has cautioned against expanding jurisdictional reach overseas and dragging foreign entities into the U.S. courts in general. This is especially the case when you're dealing with an entity that has no direct contacts with the U.S., and now you're going a step further and saying it's part of a conspiracy. If an entity acted directly through an agent to where they're essentially effectively the same entity, then I suppose you reach those direct contacts. But if it's merely these theoretical allegations of a conspiracy, you don't get there.
Let me ask you a different question. If a merchant commits fraud over the internet, this fraud in this case, selling pharmaceuticals to an American citizen sends him the money, and it turns out to be a total hoax, is that merchant subject to jurisdiction in the United States?
Well, as Judge Niemeyer, you're obviously very familiar with the ALS scan case. I believe that under those facts, that would probably be sufficient under the ALS scan case to have purposely availed themselves of contacts with the United States.
All right, so if we agree that the merchant is, then the argument that the plaintiffs in this case are making is that if the merchant is subject to jurisdiction, and if the bank is acting as the merchant's agent in carrying out the fraud, knowingly carrying it out, is there a conspiracy sufficient to bring the bank into the United States?
I don't feel that the allegations even come close.
No, this is hypothetical.
If the banks are acting as agents of an entity engaging in illegal activity in the United States, I think theoretically under the law that could provide purposeful availment. It all comes back to the constitutional framework of due process.
Well, ALSCAN dealt with, it's a difficult question, the due process clause on personal jurisdiction in the United States. I've always thought it started with a jurisdictional barrier, sort of a state sovereignty, in that you can't be hailed into a state. But Calder sort of expanded that a little bit, and I think ALSCAN takes advantage of that. We have another layer when we leave the borders of the country and we go to other countries. It's no longer due process. It's no longer American Constitution. It's now whether we can exercise our sovereign power over somebody outside of the country. And traditionally, somebody fires cannons into us, we go and take out the cannon shooter. And we take them out physically. We don't have a court bringing jurisdiction. I mean, our whole 9/11 war in Afghanistan is on that theory. It's a sovereign theory. I don't know what case the Supreme Court has addressed this most. Was it Asahi or what?
Asahi is probably the closest I've seen, Your Honor. That's the one I would have cited as well.
Yeah. And so you're reaching out to pick up people, and what comes to mind immediately is, I don't know if you remember, De Beers was accused of monopolizing diamonds, and nobody could do anything about it, or at least didn't think they could do anything about it until there was a final resolution. And now De Beers does business in New York. They came in, they resolved that, but we never went after them, and they caused enormous economic injury around the world in connection with the diamonds. I gather, even though they caused injury in the United States, we didn't think we could have sued them. Justice Department never went after them in South Africa. We have all the knockoffs and frauds in China with respect to our software, and I don't see us going after those types of things, even though there may be some contacts. I'm trying to figure out what the principles we're going to apply our sovereign power through the courts in foreign countries where people have no physical contact. The only contact with the United States is the internet and an intent to defraud. And so they do use that mechanism to suck out money of American citizens and take them. And so you would think, okay, we can go chase that money on behalf of our citizens. And that's what you conceded with respect to the merchant. And so if that's so, then why wouldn't the theory lie that if the bank was in cahoots with the merchant, helping to suck that money out of the United States?
Your Honor,
wouldn't that be a basis for jurisdiction?
it would have to depend on the level of, I guess, connection between the bank and
let's say it's the most egregious situation. I'm trying to create a hypothetical that's
Sure, Your
most
Honor.
egregious. Do we have the power, sovereign power, to do that? And should we do that as a prudent international matter?
I think the court needs to tread very carefully on that, very lightly, given the extreme implications of such a rule. I don't think the banks here are arguing that there could never be a circumstance where a foreign bank could be liable in the U.S. if the due process standards were met and the connection was made.
Why
This
do you
case
say
is so.
due process? You guys talk about due process. Do you think that they're subject to our due process laws?
Well, they have to be subject to them in order to be able to be brought into court here, Your Honor.
That's a standard we apply to the way we can exercise our jurisdiction over them.
That's correct, Your
We're
Honor.
subject to it.
That's correct. This court is subject to it and would not be able to bring these other banks without satisfying
You're not
constitutional
suggesting we
requirements.
bomb your banks, are you?
No, I'm definitely not suggesting that.
I wanna
I
be
think my
clear.
banks would be very upset if that happened.
But clearly that is sovereign to sovereign. That's how sovereigns settle disputes with armies. But
Negotiation treaties.
well, I mean, ultimately with that.
Could do
Ultimately
it,
with that.
yes.
But you don't do
Friendly
that.
manner.
You don't do that for fraud. Somebody that attempts fraud on a citizen in Virginia, we don't send the Marines after them.
Well, plaintiffs may want to in this case, but
But
no, that's normally
the
how
serious
it's
point is you don't do that.
That's
You
correct.
use the courts, and the courts you have to decide the courts have to decide when is it fair for us to exert our influence over that entity.
Right, of course, Your Honor. And frankly, Your Honor,
And by the way, let me say, I want to take you back to that old notion of general contacts and specific contacts. It seems to me it's much less offensive to the idea of due process if and by the way, we don't hail people into court. I'm from, we haul them into court. But at any rate, you bring them into court because their contacts are directly related to this event. That's what I was talking about, the specific versus general contacts. And that's what I was trying to get to. And I didn't see, I think you kind of maybe even begrudgingly acknowledge it might be possible under some scenario, if factually alleged and then shown, that you could have jurisdiction on a specific contact. Now, by the way, I'm not sure that I'm prepared to unravel exactly what that contact is if it goes through intermediaries in 5 or 6 or 8 different countries and through the banking system. I don't know about all that, but it seems to me the theory is one that's acceptable. But I do have a question in this case about whether or not any of that was properly pled. But I'll let you answer anything you want to say to Judge Niemeyer as to his question.
well, I think the key point here, and Judge Shedd, I think you touched on it very, very well, is the banks are not trying to create new law in this realm or establish an absolute framework of jurisdictional boundaries. This case is so far from the mark that it doesn't present the question that could even pose the test, could even meet the test, could even establish the standard.
But you agree. Judge Shedd makes a good point that our courts impose restrictions of due process on the way we function.
That is exactly right, Your Honor.
And whether the way we apply those principles to people outside the country, it becomes a little bit more delicate as observed in Asahi.
That is exactly right, Your Honor.
But it doesn't deny us the right, if an American citizen is injured in Virginia by fraud committed from outside, that's a little bit like firing the gun from outside and hitting the Virginia farmhouse. We can hail that person, or I think all we can do is hail them.
Hail them, haul them, whatever you...
Well, we can't haul them. We'll hail him and then try to attach his assets, I suppose.
Your Honor, there's several examples of foreign entities being hailed into court in the United States for actions that occurred overseas when they actually did, again, the court had due process requirements.
Has the Supreme Court addressed that at all?
I'm not aware of the Supreme Court addressing this issue, Your Honor. I think the Gucci case that my colleagues mentioned is an interesting example here, precisely why jurisdiction doesn't lie in this case, Your Honor. In the Gucci case, you had the initial defendant, the initial counterfeiter. It was a counterfeit goods case, and the initial counterfeiter was already had been found liable of counterfeiting. On that basis, they figured out what banks processed the transactions for that counterfeiter. The counterfeiter knew about the bank processing the transaction. There was evidence that they knew of the counterfeit transactions, that they knowingly complied with that, that they actually specialized in high-risk merchants, so that was their target market, were these types of counterfeit products, that they took affirmative steps to engage in the counterfeit activity.
Do you think this is more of an Iqbal Twombly type problem?
It certainly touches on that as well, Your Honor. We certainly could have brought that.
I know that's to say the cause of action, but we have to deal with personal jurisdiction here. Do you see, I mean, is that how you would have us resolve this? That somehow looking at the principles in Iqbal and Twombly, I know that's to say the cause of action. Sure. But we would look at personal jurisdiction that way too, and go, is there enough in that, especially as Judge Niemeyer notes, in maybe a more delicate situation, is there enough that's been asserted under those standards for us to be able to say we do have personal jurisdiction in this case?
I certainly think that's a fair approach, Your Honor, and I actually think Judge Brinkema touched on that at one of the oral arguments and one of the motions to dismiss for personal jurisdiction.
What other approach is more fair than that?
Well, I wouldn't say other approaches are more fair. I would say that there are other approaches are simply looking at it from the personal jurisdiction context, that there needs to be plausible claims to give rise.
But I thought you've already said, you may not have conceded it, but I thought you've allowed that under the right facts, you may well have jurisdiction. I thought you've already said that.
Your Honor, then perhaps I'm agreeing with you.
No, but I'm not trying to badge you on this, but it seems to me, I thought through hypotheticals that it certainly appears like you would concede that there is at least conceivable a circumstance that an entity outside, through either an agent or otherwise, could be held into this court on personal jurisdiction. But that, I thought that's a given. But so, before you can argue about the facts later in a developed case as to whether or not those suffice, you first have to look at a motion to dismiss. Question of, do the allegations in the complaint even meet the standard to be explored? Does that make sense to you, what I'm saying?
It does make sense to me. And one of the response to that would be, I agree it certainly needs to meet the Twombly-Iqbal standards. Arguably, Your Honor, it needs to meet an even higher standard than that, because that is already accepting the fact that there is a personal jurisdiction. Right now, you're dragging entities from...
I know I'm talking about something akin to that standard in our question of assessing whether or not there is personal jurisdiction. You understand?
Yeah, I do understand, and I think that is the general framework in which it could be examined, Your Honor. As I said, I think the standard might even be higher than for a 12b6 motion.
So you would do what? They'd have to have even more specific assertions?
It would have to be, as this court once stated, a threshold showing, something where
isn't that what Iqbal Twombly really is, too?
It might be, Your Honor. I don't want to split hairs on the terms, but I don't know if the showing is a higher standard.
The point I'm trying to make is this. I'm not talking about the standard that you have to meet to establish personal jurisdiction, but the standard of what we accept from the complaint as facts to see if that standard is met. Does that make sense to you?
It does make sense. I think Twombly and Iqbal do present
I thought on personal jurisdiction issues, you can't just rely on a pleading. You have to demonstrate facts. This is a motion the court can find facts on. You don't go to juries on personal jurisdiction. The court can have a full hearing, can hear witnesses, but if they just allege jurisdiction and allege some facts, they have to do more than that, don't they?
Well,
it's challenged.
That's where I was going, Your Honor. I think it would likely be a higher standard. There is a burden
but
here.
a mini trial isn't required. You wouldn't say that every time there's a person.
There's no requirement, Your Honor, of course, but that's an option.
My point is there may be that the complaint may be so deficient that you don't even qualify to have a trial on that point. Wouldn't you agree with that? On the personal jurisdiction.
If the complaint is deficient, then you
don't even
get
get to that standard. You'd have a personal. You can have a proceeding if the court has some questions about it, and the court, without a jury, could make that determination. But the court doesn't always have to have that hearing in a motion to dismiss for lack of personal jurisdiction.
Of course not, Your Honor.
All right.
All right. Thank you, Your Honor.
Thank you. Mr. Freddie?
May it please the court.
Could you just address the specifics in this case? Let's get away from the theories of the case.
Delighted.
The argument is that we had one transaction that is in the United States involving John Doe, and the claim is that we don't know whether the merchant involving John Doe dealt with these banks. Is that so?
Two questions there, Your Honor.
Right.
Number of transactions, yes. We have one specific class representative named in this case, John Doe, who tried to buy drugs. But he is a class representative standing in for what will probably be millions of class members.
But if he doesn't qualify, have a claim, no one else is going to.
And his buy, Your Honor, was processed through a bank, or pardon me, through a merchant doing business as Canadian Pharmacy. He knows the brand name on the website. He knows the name of the domain name he went to, the phone number that was provided to him on the website, and then a different domain name that appeared on his credit card transaction statement when the card was actually charged. He and I have contacted his bank to try to have his bank tell us, and this is part of the problem with all of this. I would love to have the merchants behind all of this here. As my opposing counsel concedes, there's little question that those merchants who did this to John Doe and the others is subject to personal jurisdiction in this country. It would be delightful to have them here.
I understand the problems, but I'm trying to figure out what have you demonstrated specifically with respect to these banks.
At the time of the filing of the complaint, we were not able, without a subpoena,
Well,
even with his
I'm talking
permission.
about the state of the record now.
And the state of the record now doesn't indicate which bank processed his transaction. But we have alleged that it was one of the 6 banks.
Well, that's pretty hard. Are we supposed to guess? Why don't you just list all thousands of banks in the country and say it's a world and say it's one of these?
Well, but there's a plethora of evidence that is in the record, Your Honor, that indicates these 6 banks weren't picked by us willy-nilly. These 6 banks were picked because researchers in the computer science area, cyber investigators.
Well, they show that they engage in these types of transactions, but we have a case or controversy involving a particular person who was injured. And that person is trying to recover his injury from somebody. But we don't even know if these banks are the ones that were involved in the...
It's not in the record, Your Honor, but I do know. We issued a subpoena to his issuing bank in the course of the case. And we know. It's not in the record. It's St. Kitts Nevis.
Well, what am I supposed to do?
Well, you ask, and I'd offer. It is one of the 6 banks. It's one of the 2 banks that we dismissed after Judge Brinkema granted the personal jurisdiction motions, because I don't think that having this one transaction tied to one of these 6 banks, the other 5 banks would obviously say, ha-ha, wasn't me. That bullet didn't hit me. Despite the fact...
Isn't that what our jurisprudence is about? We have cases of controversies between a plaintiff and a defendant.
But our plaintiff is a class.
No, it's not a class. There's no certification. You're purporting to represent a class. Your plaintiff is here alone right now.
I understand.
And I want to know whether this plaintiff has a cause of action against any one of these parties.
I think he does, because we don't know whether St. Kitts processed his charge where in time.
But it's not in the record which of these 6 bank entities is the party.
It's not. That processed, nor is it in the record,
So on the state
Your
of the
Honor.
record today, we would have to guess among the class of defendants.
Traditional sort of tort problem where a number of...
Most states, except maybe California, will not let you sue multiple defendants and say it was one of them. You have to make an allegation against, I mean, if you have 3 people that supplied asbestos to a plant and you don't know which company it was involved in your situation,
Right.
you're out of luck.
And in some contexts, that makes eminent sense. In the context of offshore entities engaged in internet business, it doesn't make sense.
Well, except we don't even know who he dealt with, except it was called Canadian Pharmacy.
Right. The face of the web page said Canadian Pharmacy.
And that's all we know?
No, we know a telephone number. We know that telephone. We first know Canadian Pharmacy is one of about 2 dozen brand names that are tied to about 95% of the overall volume of spam activity in the world today. It's not thousands of brands. It's 2 dozen.
Do you have a person, a human being, or a corporation that is responsible for the fraud to your client?
I know to a moral certainty that person exists. Have I identified him by name? Have I identified him by name? No.
You know, that's like saying we know something caused something. We just don't know what it was.
No, it's like saying 5 men came out in the dark wearing masks and beat me up. And I don't know.
Well, if all 5 beat you up, there's no problem. But what if only 1 beat you up?
I think that you would still, in this context, be entitled to...
You can't sue all 5. You have to sue 1 and get the right one.
Do you think 3 men are beating you up right now? Just wondering.
Your Honor, and the difference is I know your names. The internet provides a fundamental change in the context.
Well, let me just ask this straightforward question. We don't know the merchant, right?
We don't know the
transaction.
We don't know the name of the human being or the corporate entity.
Right. And therefore, we also don't know which bank was involved.
Within this record, no.
All right. So we basically have a man in Virginia who put a purchase order to Canadian Pharmacy and got a phony, never got his drugs.
Right. Drugs did not arrive.
And
perhaps seized by customs.
yeah.
We also have another plaintiff, though, Your Honor, Project Honeypot, which is an email service provider.
Have they been? How have they been injured?
They've been injured because they're in the business of providing email service to customers. And as part of that service, they have anyone who opens a mail system on the internet today, you can just plug it in. You don't even have to announce to the world it exists. Botnets run by these bad guys.
So how you been injured? How do you assert you've been injured?
Their mail server is inundated with spam at the same time that they're trying.
What's the injury?
The injury is they have to overbuild their system in order to accommodate that. 90% of the email traffic in the world today is garbage spam.
Wait 1 second. So the complaint there is a different type of injury. It's not a fraud injury. It's just you sending too much spam?
No, it's a fraud injury as well because the communications are coming from largely from compromised computers. The bad guys are putting a virus on your machine.
Now this is a totally different theory.
Sure is.
I mean, now you've got an argument. You've got an argument that some entity somewhere in the world is flooding the internet, and that entity is liable to you because your system is being flooded with spam.
What
kind of claim is that?
Well, that's CAN-SPAM expressly provides federal...
What's the nature of the cause of action?
Trespass.
There's no fraud.
Ultimately, it's trespass to chattels, and there is an underlying fraud, Your Honor. There's no government today that has immunized the transmission of spam. No spammer can acquire the services
How do you define spam?
It's unsolicited bulk email.
Okay, fair enough. That's not fraud. It's just unsolicited.
But because it's unsolicited and because my cost of transmitting it to you is trivial, but your cost of receiving it is large, we have a tragedy of the common.
Theoretically, then, anybody who receives spam in the United States can sue anybody else in the world who issues spam. That can't be right.
And yet, Your Honor, 15 years after the invention of the internet, I think this is the first case coming before you on the question. The reality.
Some principles.
I'm sorry?
We have to invent some pretty dicey principles.
No, there are well-established laws. Indeed, CAN-SPAM is a federal statute that gives jurisdiction. We've asserted on behalf of Project Honeypot a CAN-SPAM claim. I think you're...
Can you file that in federal court? I thought the spam cases had to be filed in state court.
No, they used to have to be.
They changed that?
They changed that in 2004. A federal statute was passed, which coupled spam with a CAN-SPAM has in it a fraud requirement, which is not hard to meet because in order to send spam, you can't publicly...
What's the fraud requirement of the statute?
Falsification of header information.
Of what?
Of header information.
Just where it came from.
You have to lie about where you're coming from.
But that's not.
So,
Does spam require that? You can have spam that has correct header information.
no, it doesn't require it. You could log on to Gmail and send out 1,000 emails advertising Viagra. Google wouldn't deliver your mail. Google would quickly turn you off.
Why?
Because Google doesn't permit that. You can't have a Gmail account and do that. There's no email provider in the world that will let you send spam. The bad guys have to steal their transmission authority from others in order to...
That's not part of the cause of action under the federal... You said that it's the header.
Well, but
I mean, you're taking us so far afield. John Doe is one issue.
I'm just answering your questions.
Well, I understand, but now you want us to exercise jurisdiction simply because there are spammers in the world, and these banks are responsible for the spammers?
No, I think this court can and should take cognizance of the fact that this conspiracy involves conspirators who are...
So why do they want to conspire to flood your system with spam? What's the interest the bank has in that?
They're making money off of it.
Flood your system?
Yes.
Your injury is a flooded system, is an overburdened system. That's what your injury is.
Yes, that's Project Honeypot's injury.
Well, I understand. I'm not talking about John Doe now. I'm talking about why are you in this case?
Because the bank's interest is in making money, and spammers cannot engage. The whole point of spam is to spew. They're sending...
I thought Honeypot collected spam. Does it?
At one aspect, yes.
Sweet Honey collects spam, flies.
It collects hand...
But isn't that part of what Honeypot does is collect spam?
Yes, but partly because you cannot operate and Gmail
You've been too successful at it?
Gmail collects spam.
No. You've been too successful at collecting spam, which is what you set out to do?
No, Project Honeypot's purpose is to provide email connectivity, but you can't provide that service unless you can defend the integrity of your network. In order to defend the integrity of your network, you have to look at the spam that's attacking your network. You have to take in the spam. You have to look at it and do something about it. And this case is an attempt to do that.
There's legal spam, isn't there? I mean, somebody in Russia could be setting up through on the internet. There's no fraud. They're just selling. They're selling ruby shoes that were landed in Kansas. I mean, you know, they can sell that to the whole world.
I don't want to get too deep into the subtleties of email transmission policies, but no. No one in the world can connect. No one's going to cross an international border sending unsolicited commercial email. It's not allowed. The nodes won't permit it if they know about it, and everyone technically is spending a lot of time and money, technically, trying to find ways to keep the bad guys from doing this. And that's a cat and mouse game.
Getting back to the personal jurisdiction over these banks, I think the spam case really takes some doing to get where you want to go. These guys...
Well, except one aspect, Your Honor, that I think brings it home. These banks are required to do due diligence on their merchant when the merchant applies. And if that merchant walks in the door saying, "Hi, you've never seen me before."
We know this
Azerbaijan?
Yeah, bank. Don't we have one here?
We have two here.
Two here.
First and Second National Bank of Azerbaijan.
I mean, what's the allegation that they have flooded your unit so that they've injured you with spam?
Well,
or they participated in flooding your...
Visa requires them to know their customer. That requires them in the application process to ask.
But all they're doing is processing Visa claims. They're not processing.
What they're doing is saying, you're a merchant. I'm not going to ask you because I don't want to know how are you generating these sales. You're telling me you're going to generate sales of $10,000 a day. I'm not going to ask you the basis for those sales and ask because if on day one that merchant generates $10,000...
Let's not go to too many more hypotheticals.
But It's not a hypothetical in that regard, Your Honor.
Or long
Spammers-
explanations.
Spammers have to have recurring access to Visa. Once they get cut off on Monday, they have to get access on Tuesday.
But what if there's no fraud? What if they're selling legitimate aspirin? Legitimate aspirin, and everybody that gets online and sees it, it's inexpensive, their order is fulfilled.
If it's lawful sales,
Should we be now bringing them into court for participating in that transaction?
I don't hear a cause of action. You're saying if that lawful product was being spam advertised?
Yeah.
I think it would depend on a careful understanding of the bank's knowledge. Spam
No,
is
they
nil-
understand. They understand their merchant mass markets through spam, and they sell a lot of aspirin, and their bank processes the Visa payments.
As distinguished as spam, if spam is distinguished from legitimate online marketing,
Well,
yes, spam is a crime. It's a crime in almost every jurisdiction in the
I
world.
thought you said it wasn't a crime unless it's a fraud element.
Or an incorrect header element.
That's the fraud.
And
I
yes,
don't know, there could be other fraud too.
No, that's just that fraud. That's what he says the fraud is.
No, couldn't there be other fraud with spam other than just
that
an
would be a
incorrect?
fraud claim.
the laws criminalizing spam for, I think, trivial First Amendment concerns have generally inserted a fraud
No,
requirement.
I'm talking about the statute.
And that's what I'm referring to.
Okay,
The
what's it
statutes
say?
have generally to set aside the First Amendment concerns of marketers who claim a right to spam. The laws have added a fraud component to them that qualifies the criminality so that spam that is falsified is illegal. Spam that is
So
not falsified.
You have this merchant in the high steppes of Russia, and he's got this very sophisticated system, and he markets through spam that he sells everywhere. And he says, I know those United States, they have First Amendment rights, and I'm really going to flood the United States, and I'm going to sell aspirin. And he gets quite a few processes, and they goes through their banks, and he then sends them the aspirin. Now, you're saying that that entitles you, because of this one transaction, to bring these people, not this one transaction, because of general spamming problems, which may be illegal, to bring these banks in.
If that advertiser, in sending his
It's
unsolicited
your burden,
commercial
not
email-
if. It's not if. They claim they're not spammers, and they're not supporting spammers. They're not even.
My answer is, if he's falsifying headers in sending his unsolicited commercial email.
My hypothetical, he's not.
And I would submit, Your Honor, the record in that hypothetical, the factual record would establish he's not going to sell very much. Because if he's not falsifying headers, he's not going to get
This guy
his...
has good aspirin, and he sold quite a bit.
But the
That's
mail...
my hypothetical.
The mail servers will not accept that mail. He won't find someone to give him that
I
connectivity.
think we have a lot to think about.
I appreciate the court's time.
Okay. We'll adjourn court for the day and come down to Greek Council.